This is a legal passage which I am going to dictate you at a speed of 100 words per minute. 5 seconds to go. Get ready. Start. Having heard the submission of learned advocates of both the parties, I have clearly gone through the petition and the documents placed on record, and also the case laws referred by the learned advocate of both the parties, and I find force in the submission so advanced by Mr. P.S. Lohkar, learned additional public prosecutor of the state respondent number 1, and also in the submission of Mr. S.D. Purkyasastra, learned counsel for the respondent number 2, para. It is to be noted here that Honorable Supreme Court in the state of Haryana and others versus Bhajlal and others, while dealing with the circumstances under which an FIR complaint can be quashed in para number 102, held as under 102. In the backdrop of the interpretation of the various relevant provisions of the code under chapter 14 and of the principle of law enunciated by this court in a series of decisions relating to the exercise of the extraordinary power under Article 226 or the inherent power under Section 482 of the Code, which we have enacted and reproduced above. We give the following categories of cases by a way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may be possible to lay down any precise, clearly defined, and sufficiently channelized and inflexibility guideline or rigid formula, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. 1. Where the allegation made in the first information report or the complaint, even if they taken at their face value and accepted in their entirely, do not prima facie constitute any offense or make out a case against the accused. Number 2. Where the allegation in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense, justifying an investigation by police officers under section 153 bracket 1 of the code except under an order of a magistrate within the preview of the section 155 bracket 2 of the code. 3. Where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. Number 4. Where the allegation in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155(2) of the code. Number 5. Where the allegation made in the FIR or complaint are so abused and inherent improbably on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. Where there is a express legal bar engrafted in any of the provision of the code or the concerned act to the institution and continuance of the proceedings, and or where there is a specific provision in the code of concerned act providing efficacious redress for the grievance of the aggrieved party. Where a criminal proceeding is manifestly attended with malafide, and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. It is to be mentioned here in that in the case of Honorable Supreme Court had concluded as under in respect of exercising the power under Section 482 CRPC or under Article 226 of the Constitution of India for quashing the FIR as under. Police has the statutory right and duty under the relevant provisions of the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate into a cognizable offence. Courts could not thwart any investigation into the cognizable offence. It is only a case where no cognizable offence or offences of any kind is disclosed in the first information report that the court will not permit an investigation to go on. The power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of rare cases, not to be confused with the formation in the context of death penalty. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise. Stop. Thank you.